Hello, welcome to the Donna and Otis Educational Series. My name is Donna Mason. I'm a shareholder with the law firm of Segan Mason & Mason, and this is Otis Tufton Mason, our newest addition to the staff. And today we're going to talk about the basics of collection in community associations located in the state of Virginia. The first step to collection when it gets to the law firm level is for us to obtain a judgment against the association debtor. To obtain a judgment in the state of Virginia, you need to go to the General District Court. There's a court date assigned, and if there's a contest with the debtor, then there will be a trial signed. Otherwise, on the first court date, you can obtain the judgment. Now, when you obtain the judgment in Virginia, it's a very excellent tool to be able to collect after you obtain it, because you can do different types of collection strategy, like garnishment. Now, garnishment allows you to garnish a bank account, it allows you to garnish wages, or it also allows you to garnish rental income. So if you're dealing with an investor, it can be a very quick method to collect the judgment. In addition to that, a judgment once docketed in the circuit court is good for 20 years. So that means that you can take that judgment and you can docket it to different jurisdictions even and attach to different properties they may own in, let's say, Fairfax County, even though the community association is in Loudoun County. So that's also a great way of collecting if there is an investor who has various properties throughout the state of Virginia. You can also take the judgment and domesticate it in different states, and that creates liens against other property that they may own, or it gives you the ability to do garnishments. If they're working, for example, in Maryland, you can domesticate your judgment in Maryland and be able to attach the wages in that state. In addition to the means of collection, if you don't have an asset that you're aware of, then it allows you to bring the debtor into court and answer what's called interrogatories. And that's where they have to answer questions under oath with the court and disclose their assets. You can ask them to bring in documents such as tax returns or so forth to make sure that you're getting correct information for collection. Now, the tool that we're used to with community associations, which is authorized in the governing documents and in the statute, is the Memorandum of Lien. The Memorandum of Lien is also a great tool for community associations. Unlike the judgment, it does not require you to go to court in order to record it. It's recorded in the land records like a deed. The lien is good for 3 years, unlike the judgment that is good for 20 years if it's docketed. Also, the Memorandum of Lien only creates a lien against the community association's property. It does not create liens against other property the owner may have, like the judgment when you docket it in different jurisdictions. Now, the Memorandum of Lien creates a lien once it's recorded, which in order for a closing company to be able to provide clear title to a buyer if there's a transfer, they would have to pay that off. Also, if the owner was going to refinance, they would have to pay it off. So those are quick and easy ways to get the liens paid if you know those are happening. The Memorandum of Lien can also be the tool for foreclosure. Now, there's two types of foreclosures. There's the non-judicial foreclosure, which is the process that's outlined in the Property Owners Association Act or the Condo Act if it's a condominium. And that does not require you to go to court in order to foreclose the lien. But the problem with that type of foreclosure is that you have to generate enough money from the sale to pay off the mortgage companies on the title. Now, the problem is the mortgage companies a lot of times will not provide us with payoffs because of privacy reasons. So it becomes very difficult to utilize that. And in many instances, the property is underwater, so there would never be enough funds to generate from a sale in order to pay off those mortgage companies. So because of that, in this time of age, we haven't been able to utilize that practice too often. However, the judicial foreclosure is what we use a lot today, and that handles properties that are underwater, meaning that there are more liens than equity in the property. However, a judicial foreclosure does require you to go to circuit court. If you're filing a complaint, you're bringing in all lien holders to the suit, not just the owner, but the mortgage companies, any judgment creditors. They're all parties to the suit. So the good part is because the mortgage companies are part of the suit, they will be required to provide payoffs of their debt. So we don't have that issue of privacy. The court order can transfer all the liens from the title to the proceeds generated at a sale. So if you have a property that's underwater, for example, there's 300,000 of liens and the proceeds is 150, the 300,000 of liens are going to transfer to the proceeds. And of course, many of the judgment creditors and mortgage companies will not be paid in full, but they're paid in order of their priority. And that allows us to have a transfer of the property and hopefully get somebody in there that is going to be able to pay their dues on time. The second thing is that we can usually get a better price for the property because the court can allow us to use a real estate agent, and that real estate agent can generate a better price than what would happen at an auction at a foreclosure sale. I hope you found this educational video informative. If you would like to discuss anything about this video, please feel free to give me a call. This will be posted on our website at siegenmason.com. Stay tuned for the next Donna and Otis educational series on drafting pet rules. Say goodbye, Otis.